All right. So, what we're going to be doing today is some studying, because a lot of you need to start learning these things. So since I came across this great piece of material, I thought maybe you would want to have a study partner and actually learn these things with me so that you can become more fluent in the way to conduct yourself. So, what we're going to be doing is we're going to be reading the preface to the first edition of a treaty on suits and chancery. Now, if any of you have ever followed or seen any of Warwick's study videos, the ones that teach you how to conduct yourself in the private and how to operate your trusts and how to conduct yourself in courtrooms and things of that nature, you'll notice that Warwick mentions Mr. Henry R. Gibson. Well, Mr. Henry R. Gibson is the one that put these works together. Now, just to be sure that you understand how serious this book is, this is not just some random book off the streets, okay? This actually comes from your Cornell library. So this is the name, right? This is the jurisprudence of equity, right? A lot of things, everything that you're going to be doing moving forward once you've established your estates and your trusts and things is operating in equity. Now, the first thing that you need to know about equity is the fact that you cannot invoke equity without there being a trust. The trust is the thing that can only be dealt with in suits and chancellory and courts of equity. So in order for you to have your equitable interests that are tied to your securitized agreements intact, you need to actually have yourself access to a trust. Okay, so when I speak to you guys about establishing your estates and setting up your trusts and things like that, this is what it is that you're going to be bringing into fruition in the type of actions and remedies that you'll be able to enforce. Okay, so this is one of the books that I've added to the library recently, right? And it'll make it so that, you know, if you're in the library, like if you have access to the study group in the library and things like that, this is a book that you now have access to. It's in the 2025 folder. Okay, so what we're going to be doing is over the course of the next month or so, because this is like a 1,200 page book, right? So over the next course of a month or so, we're going to be making videos reading each part of this book as we go through these things and try to teach you about how you're supposed to operate and how you're supposed to conduct yourself in the private, because that's what this is. The only place that you can experience equity in America is through trust law. Trust law is what gets you your equity. Now, the reason behind that is because only living men and women have the ability to control a trust. So it's the laws that are fair and equitable versus your statutory versus your municipal versus, you know, all the things that you're trying to get yourself away from. So as you're going through what is known as status correction, what you're actually just going to be doing is learning how to operate in the private. And as you operate in the private, you have to be able to conduct yourself in a way that's going to be feasible, that's going to be manageable, and you need to be fluent in the things that you're doing. And so learning these things will give you the ability for you to articulate yourself when it comes to dealing with things like corrupt judges and courtrooms and things of that nature. Okay, so these are the very things that become the foundation of the way that you're going to be living your life once you've actually established your trust and make it so that you're able to actually move forward in these venues with as little bumps in the road as possible. Do you understand? Do you get what I'm saying to you? These are the things that you're going to need to study. These are the type of things that you should be focusing on your weekends and on your weekdays whenever you have your free time. These are the things that you need to start looking into so that you know how to utilize those instruments that you've created. Otherwise, you've created them for absolutely no fucking purpose at all whatsoever. Right? It's cute to have your trust set up. It's nice to have your estate in order. But if you don't know how to defend it, if you don't know how to stand on it, and you don't know how to present it, then you're always going to be under the assumption and presumption of being one of the wards of the state, making it so that you fall right back into the same jurisdiction that you've just spent all of your time and efforts getting out of. So, suits and chancery. Right? Now, the reason that it's so important for us to start learning this is because we've already created a chancellory court. Right? We the people have a court that has been created recently, within the last week. It's taken a few months for all the documents to go through and all the paperwork to go through. And we're working on getting the websites together and putting everything together so that you'll be able to send your court cases to it so that you can actually have a court of equity that won't be overridden by corrupt officials of a system that's ran off of commerce that's trying to force you back into their jurisdiction. Right? No more of the games and the bullshit. Is basically what we've done. So very shortly, very soon, we will make it so that you will have access to that court. We just have to finish getting things in place. Okay. So once I finish getting the funds together, it's quite expensive, to be honest with you. It takes a little bit of funding to actually put these things together, you know. So now that we have the paperwork all filled out and set up, it's going to take a little bit of time to get it fully enforced. But we've already got our agents of the court being put on notice. We've already got all of the people that are necessary in order to conduct this court successfully for we the people operating on the best that they can to make this move as smoothly as possible. I don't have to fucking interact with anybody when I'm speaking to everybody in here. Maybe you should learn how to have some fucking patience, and then you wouldn't be worried about how my interaction goes. Okay? Because people need to know what it is that they're being involved in. Sometimes you should shut the fuck up and just wait until somebody has the time to address you. When you go into a classroom, you don't fucking speak while the teacher's speaking to you, do you? No, you sit there patiently, quietly, waiting for the time for the teacher to ask you if you have any questions. That makes a lot more sense, right? Instead of interrupting people and trying to dismantle everything that they're doing, you would think that considering it's something that you want to speak on, that you would actually have a little bit more respect in that. It's called being honorable in the ways that you conduct yourself, which you're supposed to be. And for somebody that has a name or a title that implies that you're sovereign, operating in honor at all times is something that you should be already used to. Right? Now, as I was saying, right, if you've been in my library, right, if you're one of the people that has access to the library and you've watched those Rourke seminars that teach you how to operate in the private and teach you how to conduct yourself in courtrooms and teach you how to set up your trusts, right, if you've watched those videos, you'll notice that he mentions Mr. Henry R. Gibson as one of the people that was assisting him in putting all of his works together. So when he mentioned him, we went and found his book on the jurisprudence of equity. This way, if you're not able to attend the lives and you're not able to watch the videos all the time, you have the ability to actually go back into the library itself and pull this book up so that you can study it on your own time, right? And then come back to me with questions that you have about it. Okay? So, if you notice, where's my pen? Oh, no problem. Look, if you notice, right, you have your pleadings, your writs, your orders, your reports, your decrees, and other proceedings in suits and chancellory from their beginning to their end. Right, so this is going to teach you how to create your own court documents. This is going to teach you how you can conduct yourself and be successful in the court rather than having to hire an attorney or keep other people with you. So now you understand the importance of what these things are. Right. So I know that as we go through this, that there's going to be a lot of things that are going to make it so, like, a lot of you are just starting to get into legalese and understanding the words that we're going through. Right. So if we come across something that you're not sure about, just do me a favor and put it in the chat. And once I've finished with that page, we'll go back and look at the questions that are in the chat, and I'll try to answer them for you the best of my capabilities. Anything that I'm unable to answer myself, we will then start to look it up together so that we can learn these things together and become fluent together. Because the thing about this is that we each have to learn these things, but it's easier to do it as a group because one person's question, you might not feel very comfortable asking that question, but somebody else might ask it for you. Right, so what we'll do with this is every Sunday we'll meet, right? You come on here every Sunday and we'll get together and we'll go over this book until we complete this entire book. All All right. And by the time that we're done with this, everybody that's in these lives with me is going to be very fluent in the way that they conduct themselves in their court matters. All right. So this is going to help out a lot of people exponentially without having to go to random people that don't make it easy for you to understand and comprehend. Yes, this is suits and chancery. Okay. The jurisprudence of equity. Okay. This is your foundation of equity. All right. So, for those of you that have the library, you can go into the 2025 folder. All right. Okay. You go into your 2025 folder. All right. You just search for 2025. All right. And you open up your 2025 folder and you come down to right here, Treatise on Suits. Okay, this is where the book is located inside the library. Okay, once we get done with the treatise on the suits of chancery, then we're going to get into the American jurisprudence books. Okay? So we're going to be going through these things over the next couple of months so that everybody can become more familiar with these things so that you don't get so lost when you're listening to people speak to you about litigation and how you're actually supposed to conduct yourself. A lot of you don't really have the time to study these things on your own, and I understand that. So all of the lives that I create here will be reposted on YouTube. Okay? So we're going to keep it as simple as we possibly can. And as we move through these things, these are the few books that I just added in here, right? Your book on negotiable instruments. Okay. This will be a nice book for you to learn about for all of you that are trying to learn about how to actually create your own negotiable instruments. This is your entire law book on it. Okay. This is from 1904 when all of these things were being created and all of these things were starting to be put into action. So these are the books that you're going to want to be looking for when it comes to actually learning about these things. I'm sure that plenty of you have heard of the law of merchant. All right, well, this is where it all began. So these are the things that are actually going to teach you how to do it. Not all that other new age shit that everybody's trying to teach you about. Okay? These are the foundations of how these things came together. Now, so let's get back to the suits and chancery. Now, just so that you know that this isn't official, it comes from the Cornell Law Library, okay? From the Cornell University. This is what the lawyers in them, actually, they don't even study this stuff. For some weird reason, they study everything else, but they stay away from the books on equity because equity is not found in a court of law. Equity can only be found in trust law, and trust law, ecclesiastic law, trumps statutory, it trumps common law, because those are things that have to do with baseline punishments, whereas equity is something that deals with what's fair and what's just. Okay? Everything inside of your Bibles that speak on righteousness, what they're talking about is equity. All right? Yeah, they study all the statutes and codes. This supersedes that, okay? You cannot have your statutes and codes without equity. Equity is the answer to all of that, all right? So, let's dig in. Now, if you don't mind, give me 1 second so I can set up my other tablet so I can put a tapper on so that you guys can pay attention instead of having to worry about tapping the screen. If you just give me 1 second. See, I try to take care of everything, right? I try to take care of everything ahead of time so that you don't have to do anything but stay fucking focused, okay? So while I'm setting this up, take a moment to get your pencils and your pens or your notebooks or your pads or whatever the fuck to take your notes on, okay? Always take notes. If you remember, when I first started studying all of this stuff, I had about 10 composition books that I filled up with notes that I was taking. If you don't take notes, you're not going to remember it. You have to write it down. Okay? If you don't write it down, you're basically wasting your time. Your brain will not comprehend it without the law of 3, 6, and 9. The 3, 6, and 9 is the 3 times, right? While I'm speaking it to you, you're reading it, so you're hearing it while you're seeing it. And that's making it so that it's compacting the way that you're being affected by it. When you write it down, you're now giving a physical form of something that you're listening to, which gives you a visual tied to it. Now you see that starts to create a habit within your brain of locking in the information. So if you don't write down your notes, you're going to be lost in the sauce forever. Until you've actually trained your brain to start fucking retaining stuff, that is, okay? So give me 1 second while I set up my little tablet to tap the screen for you. And then we'll start reading from this beautiful book that I've gotten so that we can actually learn together. Because I know that I talk to you guys about a lot of this stuff and a lot of it gets really confusing, but this should help clarify a lot of it for you. So just give me 1 second while I put this together on my end. All right, what profile is this? Okay, I need to switch profiles. I think let's go to this one. So just give me 1 moment. Hey, good afternoon. Welcome, welcome. Everybody get nice and comfortable. The tablet's a little bit slow, so give me a second. Once it's set up, we'll begin. I'm just waiting for it to get together. Here we go. No. I need... God, this thing's slow. Why is it logged into this profile? I'm gonna go to this one. Alright, let's go to here. Go to the inbox. Close that. I need the Book of Johnson. Oh, I just found Smoking Babies on here. Nice. I gotta add him to this profile. All right, let's go to the live, follow, and we should be good to go. Yeah, got it, whatever. Turn on my tapper. Let's put this bad boy over here, like this, and press play, boop. All right, there we go. Tapper's running. All right, we're officially in business, ladies and gentlemen. Make sure I follow myself. Bloop. There we go. And that should be good to go. All right, so. All right, is everybody ready? Put a 1 in the chat if you're ready to start digging in. If you got all your paperwork together, put a 2 in the chat if you still need a moment to finish grabbing your stuff. All right. Let's get to moving then, shall we? Now. Entered according to the Act of Congress in the year of 1907 by Henry R. Gibson in the office of the Librarian of Congress at Washington. Okay, this is a real thing. All right, some people still need a little bit more time. All right, I'll give you guys a couple seconds. Anybody got any questions while we're waiting for them to finish getting their pens and papers together? Oh, no problem, man. This is how this is how we get things done, you know? So just do me a favor. For the people that said that they needed 1 more minute to get your documents together and your pens and papers and stuff, just do me a favor and let me know when it is that you're ready. Just type in the word ready when you've gotten those together. While you're doing that, we're just going to read the preface, okay? While there is a general final While there is a general family resemblance between the systems of jurisprudence prevalent in the various states of the Union, the differences and peculiarities in their systems of pleading and practice are nevertheless so great that no work dealing with the procedure in courts is of much practical value to the practitioner, unless it's adopted to the jurisprudence and the practice of the particular state in which he lives. Books of general practice with footnotes of the diverse rulings in various states are often more confusing than enlightening. What the practitioner needs is a book of court procedures that omits everything that is not the law in his own state, and contains everything that he is likely to need in the progress of a suit. Such a book I have endeavored to make this, so far as the chancery practice is concerned. Okay? Now, what ordinarily happens in a litigation can well be compressed into one volume, but what very seldom happens, the unusual and the impossible, will fill several volumes. What happens in matters of pleading and practice in 99 out of every 100 suits I have labored to give. What may happen in the 100th suit I have not striven to forecast. The ordinary law is comparatively small in compass. It is exceptional and the uncommon that necessity a multiplicity of books and fill libraries. And while I have not attempted to give what is exceptional and uncommon, my purpose has been to give everything likely to prove of value to be found in our statutes, decisions, and rules of practice, and in the standard authorities on the subject. So the matters of equity and jurisprudence, this work is based mainly on Pomeroy's story and the statutes and judicial decisions of our own state. In matters of chancery pleadings, I have followed story in so far as consistent with our statutes. Daniel and Barber have also been drawn on quite largely. The many differences between our system of pleading and that of the English Court of Chancery are clearly pointed out where necessary to prevent confusion. In matters of chancery practice, the works of Daniel and Barber have been relied on when consistent with our statutes, decisions, rules of practice, and systems of jurisprudence. Okay? So, basically what they're saying is that what they're doing is focusing their points of jurisprudence on the works of some people that have actually been successful in the chancery courts, which are the original courts which you find in Great England. Okay, that's what the American court system is now based off of, for the most part. Okay, so in drawing the forms, pleadings, orders, and decrees, brevity, simplicity, perspicuity, and precision have been constantly kept in view, and surplusage and prolixity have been avoided and reprehended. In the arrangement of the contents of the book, everything has been given in the order of time in which it usually takes place in progress of a suit, when possible to do so. In providing means for finding any particular matter in the book, a full index has been given in the back part of the book, and a complete table of contents in the front part of the book, and the titles of the chapters and articles have been given in the top margins of the book, and many cross-references will be found in the footnotes. Each section begins with a statement of its subject in bold-faced type, and the object of this work is to aid those who minister in the chancery courts and to continue somewhat to the improvement of the pleadings and practice in these courts. Okay? Hey, greetings. What's going on, man? So I see we lost a couple people there. You see how quickly people run when it takes time to actually learn stuff, right? Now, whatever a man does, he flattens himself he can improve on. Right? Whatever a man does, he flatters himself he can improve on. And so the author of the first edition of this work, better aware of its deficiencies than anyone else, began the preparation of what he hoped would be an improved edition before the first had been fully printed. The main object of the original edition was expressed in its title and preface, but it left many suits in chancery unconsidered. The left and left others very imperfectly considered. To supply these deficiencies is the main object of the present edition. The deficiencies in the first edition were caused first by an apprehension that the necessary additional matter would make too unwielding a volume, and second by the author's duties as chancellor engrossing too much of his time in preparing this edition. The author has had adequate time and the suggestion of a considerable proportion of the lawyers of the state, besides the use of the law library of Congress for over 10 years, so he hopes the deficiencies have been reduced to the minimum consistent with one volume. So, why do you need the name of the previous book if you're... See, this is where you're going to mess up, okay? Now, I already told you that these videos are going to be going onto YouTube. So follow along with what we're doing here, and then go back to YouTube when I post it, and you'll see what the name of that book was so that you can go and find yourself a copy of it. Or if you have my library, you already have a copy of it. Just so you know. All of these are in my library, okay? Now, this present edition, which contains 20% more matter than the original, treats of every kind of suit in chancery the average lawyer will be called on to bring or defend in an average lifetime, the suits often brought being most fully considered. Okay? The author cannot forbear expressing his gratitude to the judges and the chancellors of the state and to the members of the bar for their kind reception of the first edition. It largely compensated him for the drudgery devoted to its compilation and publication. In this connection, it may not be out of place to say that none of the references to reports in the textbooks in either edition are second-hand, but are the results of original investigation and can be implicitly relied on. The code references are, unless otherwise noted, to the Code of 1858. The reasons for this are, first, it is the only statutory code of the state. Second, all subsequent codes contain it so far as extent. And third, this work may outline the temporal codes of individuals, of which have been 4, but cannot hope to outline the code of the statute. The code of the state. Statutes passed since the Code of 1858 are usually referred to by the date and the chapter of the act. The quotations of maxims to illustrate the text will, it is believed, prove helpful. No book that treats of equity is complete without them. They are not the mere gewgaws of pedantic lore, but the crystallized wisdom of the law, polished and preserved by the masters of jurisprudence. All right. Now, contents. All right. So, I think we'll give the opportunity to decide which ones we want to go through. I'm not sure necessarily that this is a book that has to be gone through one by one by one. You understand? So, if you notice, there's articles, right? And each article that's in each chapter contains a different type of information, right? So the origin and evolution of equity jurisprudence is pages 1 through 9. So why don't we just start with that? I think we will just run through this from the beginning to the end. I think that'll be the easiest way to keep things structured. But as you can see, there's a lot of chapters here. So this is going to be a lot of Sundays, all right? So if you come in here this Sunday, you might as well be here on the next Sunday too. Because we're going to go through this whole entire thing, and there's something close to 1,200 pages. Right? Now, before we move forward, I'm going to skip to the very end of the book because they said that there's some things in the back of the book, and for the people that don't have my library, I want you to have access to these things because I believe these are reference points that they created for the book. And so what we're going to do is give you the chance to screenshot some of them really quick before we move forward, okay? Give me 1 second. Let's get to the back of this. Alright, index forms. Okay. Alright, so let's see. Where's the index start? These are all... Okay, here we go. Index to forms. Okay, so do yourself a favor and get yourself screenshots. This is suits and chancellory. This is jurisdiction of equity. The jurisprudence of equity. Okay, this is the foundation of equity and explains to you how you conduct yourself in all courts. This is basically learning how to perform your rights and create your own litigation so that you don't have to go to outside sources, because if you're going to be operating as sovereign, you're going to need to do so from the standpoint of somebody that is educated in these matters. And so you need to be able to conduct yourself properly, okay? So we're going to go to each page, go like this. Let me see if I can shrink it down to get a whole page on the page. Almost. All right, so that's pretty much the whole page, right? So there's a few pages that you're going to want to screenshot. So I'll give you just a moment to do so. Matter of fact, here, I'm going to do something. I'm going to remove the comments so that I can fit most of it on the screen, okay? Let's see, where's the settings at? Settings. Get out of there. Comment settings. Turn the comments off. Boop. Ah, there we go. Now you can see the whole thing. All right, so now you can get your screenshots. So I'll give you a couple moments per page. Give you 1, 2, 3. That should be long enough for you to get a screenshot here. We're going to the next page. This is the full page. Yeah, all right, that's your full page. All right, so make sure you get your screenshots in. Let me back this out just a little bit. There you go. All right, so if you don't have access to my library, you're going to want to screenshot these because these are your reference points, okay? Moving on to the next page. All right. Give you a couple seconds. 1, 2, 3. One, two, three. One, two, three. I don't know, this part's gonna take a couple seconds, but just bear with me. We're just trying to make sure that everybody has the ability to use this, okay? There we go. Make sure the whole thing's on there. 1, 2, 3. I wonder. It kind of aggravates me that they have all this crap on my screen. I don't know if you guys see it or not, but I see it. Let me see if I can just go like this. All right, there you go. If I can shrink it just a little more. There we go. That's perfect. All right, so make sure you get your little screenshots in. We're going to move along. There's quite a few of these pages. Don't worry about tapping the screen. I have my screen tapper going. Down a little bit. Okay, this is going to get you comfortable with your civil procedures and how you conduct yourself in the court of law. Okay, that's what the basics behind this is. All right, so for those that are freshly coming in here, that are wondering what it is that's going on, people are getting their screenshots of the pages that don't have access to my library so that they are able to have their reference points before we move forward with this. Okay, so if you're new in here, these videos will be posted on YouTube afterwards. We're going to give it about an hour per Sunday studying this book. Okay. And so these are all your references that are in the back of the book for you to be able to go back to if you need to check on something. So I know that this is a little bit of a slow process, but you know, gotta do what's right so that everybody's able to gain from this, okay? This fucking thing. There's interesting stuff on these pages. I don't know if any of you are peeping out what's actually written on these pages as we're letting people copy them, but you know, if you pay attention to some of the litigation on here, some of these words are pretty key. We're almost done. This is just going to make it so that whenever the people go on YouTube or whatever and watch this, if you're not getting your screenshots now, you'll be able to get your screenshots off of YouTube later. So don't worry, this whole section is going to be on the YouTube video. So we're going to give this a minimum of an hour. And by the time we're done with this book, we're going to have a whole bunch of people that are fluent in how to conduct themselves in the court of law, that don't have to ask anybody for help anymore. That's the whole point of this. As you're going through sovereignty, the whole point of sovereignty is learning how to conduct yourself on your own and learning how to stand up for your own shit, okay? So this is very important for all of you that are interested in getting your estates and getting your trusts and getting access to your Cesta QV trust and all that shit. All that shit ties into this, because this is how you're going to conduct yourself in the court of law from now on. And without knowing these things, you're basically going to be going in there with nothing to back yourself up, basically. You're going to be going in there and you're going to get shitted out and put right back into the public domain, and you don't want to do that, okay? So I hope everybody's getting their little screenshots in. We're almost done because we're already up to the R's. Sales and chancellory, Skyer fascias. See, there's some new stuff in here I'm going to be learning with you. I don't claim to know all of this stuff already. So just take your little screenshots and then put these in your own little personal libraries. Okay? And I think we're just about there. All right, that's it. All right, now going back to the first chapter. So let me get it so that you guys can fucking comment again. Give me 1 second. Comment settings, allow comments. All right, back in business. All right, so let's get it back up to that first chapter and let's start from there. What up, Dax? Can I use that fucking bar on the side of the screen or what? Oh, there we go. But yeah, we're going to be at this for a couple of months, okay? And we'll add in a couple other books as well for other things to study while we're going through this. Ah, wait, here we go. Part 1. All right, here we go. Oh, I'm live all the time. Frisbee Mike, this is the Treaty on Suits and Chancery by Henry R. Gibson. I'm gonna repeat this for the last time. If you're familiar with the Rourke videos that are in the library, I'm pretty sure you are because you're in my library. The Rourke videos, if you pay attention when he's speaking to you about chancery, when he's speaking to you about jurisprudence, when he's speaking to you about private exclusive equity, it's Mr. Henry Gibson that was his assistant, or I wouldn't say his assistant, but the person that he was learning with, okay? So we're going to go over this together, and, you know, whatever questions you have, I'll try to answer it for you. And we'll get this moving. Sorry about that. Now, so the Chancery Court, right? Its history, the jurisdiction, and principles. The history of the Chancery Court, the origin and evolution of equity jurisprudence, the history of Chancery Courts of Tennessee, right? These are your 2 articles that are taking place here. So, now, if you don't understand the equity jurisprudence is the foundation of all of the trusts that everybody has you setting up. Like if you're one of those people that's learning how to operate in the private, the first thing that you need to know, and I'll show you this real quick. If we pull up trusts in the Black's Law Dictionary, let me get that for you. Jurisdiction. Trust. All right, so if we go to trusts in the Black's Law Dictionary, the first thing that it tells you about the trust, where's it at? All right, if you notice, give me this. If you notice in the Black's Law Dictionary, right here under trust, right, the right enforceable solely in equity. All right, that's the key thing about your trust, is that your trust is only able to be enforced in a court of equity, right? To the beneficial employment of property to which another person holds the legal title, a property interest held by one person, the trustee, at the request of another person, the settlor, for the benefit of a third party, the beneficiary. For a trust to be valid, it must involve specific property, reflect the settlor's intent, and be created for a lawful purpose. The two primary types of trusts are private trusts and charitable trusts, okay? So the first thing that you're typically going to be setting up when you're learning how to operate in the private is what? Your private trust. All right. Now, after you make your private trust, that's when you're going to create your charitable trust, which is the one where your 508c1a goes into, so that you're able to start taking donations for the trusts. Okay, so a fiduciary relationship regarding property and the charging of the person with title of the property with equitable duties to deal with it for another's benefit. The confidence placed in a trustee together with the trustee's obligations towards the property and the beneficiary. A trust arises as a result of a manifestation of an intent to create it. See fiduciary relationship. The property so held, the corpus. Notice how it's the corpus, right? This is the Black's Law Dictionary, okay? This is like the 11th edition. This is the most current one, okay? So this is the one that's going to be the most current on how they're operating things, but you're going to have to get older versions of the Black's Law Dictionary in order to look up certain definitions of things. They've been removed from the Black's Law Dictionary, okay? So what we're going over is the Treaty on Suits and Chancery, okay? That's what this book is. Oh, the 4th edition is the best edition. The 4th one is the best edition of the Black's Law Dictionary, right? These ones that I have, like this 11th one that I have, this is just updated for commerce, right? That's the only thing that differentiates between the old versions and the new versions, is that the newer versions have more to do with commerce and then. Well, I can't say that the other Black's Laws don't deal with commerce, because that's specifically what it's really about. But the older Black's Law dictionaries have more definitions for other litigation that deal with outside of commerce, rather than these ones that have been edited and changed to reflect the new ways that commerce is being handled. Okay, so it might not contain the same old definitions as the other ones do, but it's still going to have the general information. It's just not going to have the definitions that the other ones have, right? Because certain things aren't being utilized in the public anymore, okay? So, all right, let's get back into it. Now, any words that we find in here that we don't know what the fuck we're talking about, we're just going to pull up that Black's Law Dictionary to go looking for it to see what it's talking about, okay? That's how we're going to do this. So you're going to study with me, all right? That way we can learn this together. Because all of you that are in here because you've been learning about trust law with me, because you've been learning about how to operate and control yourself in the private, and so this is basically the foundation of that, okay? So this is very important, all right? Oh, good. That'll help out. Now, so Article 1, the origin and evolution of equity jurisprudence, the civil law, its development, the evolution of equity in England, right? Because this is where your chancery courts came from, is England, all right? The chancery courts are what the United States of America, what the system is that's basing it off of. They're based off of the chancery courts, okay? These are the original ones where you have your esquires instead of your lawyers and, you know, things of that nature, okay? These are where all the terms come from. So, No, common law is not. Look, don't even fucking don't even speak to me anymore. Common law is not higher than equity because common law deals with statutes. Common law is statutory law, okay? It's no different because it's the law of the land, which is very brutal in its fucking conduct. Equity, however, deals with what's fair and just. Okay, so if you're dealing with common law and you go into a marriage court and you're dealing with common law, under common law, you can have your property taken from you and given to somebody else that you're married to. Whereas if you're dealing with equity, what actually happens is what's fair and just, right? When it comes to equity, what has been done is done, which means that there's literally no reason for you to really be in court in the first place because it's already been settled by the actions that took place. You see, common law is a very brutal law system. That's for people that don't know how to operate in the private, that actually operate in the basic form of life. Okay, yeah, equity is the divine law. Okay, so please don't tell me that common law is higher than equity, because common law deals with man, whereas equity deals with the creator's instructions. Now, I don't know how auto text makes a difference. All right, look, I'm not going to sit here and argue with you. I'm going to make it real simple. If you keep speaking that nonsense instead of learning, right? Because clearly you haven't dug into this information enough to actually understand what it is that you're speaking to me about, right? Equity trumps common law. Equity trumps statutory law. Equity is the foundation of all laws. So equity, you might have laws that are created for man, but equity deals with what is easy. No, you're not trying to help when you're arguing with me about things that you haven't studied. So, civil law, its development. The system of jurisprudence called equity was originally largely derived from the civil law of the Romans, and its early development in England was similar to the development of an analogous system in the jurisprudence of Rome. Therefore, in endeavoring to trace the origin of chancery courts, it may be well to notice briefly the development of the civil law. The early laws of Rome, like the old common law of England, were exceedingly stern, rigid, formal, and arbitrary, paying little attention to abstract right and justice. Their judicial proceedings were technical to the last degree. Absolute accuracy was required in complying with the establishment phrases and the acts of the enforcement of the civil rights. Any omission or mistake of word or movement was fatal. As civilization, however, progressed in Rome, subtle technicalities gave way to simpler methods of pleading. But even then, it was found that the cases occasionally arose to which the improved formulas were inadequate. These extraordinary cases were decided by praetor without being referred to the ordinary tribunal, and without being hampered by technical requirements as the proper formula or kind of action, he himself determining both the law and the facts of the case. The complainant stated the facts of his case, the defendant set up his defense, the praetor, I think that's been updated, the practitioner, decided. This extraordinarily method of determining suits, so simple, so free from technicality, so easily molded to the exigencies of the exigencies of every case, was found so superior to even the improved formulas that eventually it superseded them and became the only mode of procedure, much as in as many of the states of England, and procedure by bill and answered has supplanted. Man, they got some words in here, right? By the bill and answered supplanted the rigid formulas of common law actions. See, it's already telling you right here that common law is definitely something that you don't want to be involved in. Not only were the pleadings thus simplified by the Roman jurists, but the law was correspondingly improved, and the deliberate and persistent effort was made to bring their jurisprudence into perfect harmony with an absolute impartial equity that should do equal and perfect justice to all, and thus was perfected that system of jurisprudence known as the civil law, from which are derived many of the maxims, principles, and doctrines of equity now followed and enforced in the chancery courts. So, what are they saying right there, right? Basically, they're saying the same thing that we were literally just having a discussion about, is that common law is very brutal in its nature, because in common law, it doesn't guarantee that everybody has a remedy. It guarantees that one person has a remedy and one person has a punishment, whereas equity makes it fair and just for everybody that's involved. You see, equity makes it so that everybody has a chance to come out of it with a gain. Right? That's the difference between common law versus equitable, right? Equitable actions are things that are beneficial for both parties, whereas common law is more, I'm gonna get something good and you're gonna be fucked. That's common law, right? In common law, there's a loser. In equity, everybody is held accountable and everybody is put into a position where there is a basic, not even financial gain, but there is a basic way for everybody to come out happy in the court of equity. You understand? Do you get the difference between the two? If you get where I'm going with this, press 1. If we need to speak on it a little more, press 2. Ashe. All right, and give you guys a moment to let me know where we're at. All right. Okay, right? So I want you to think about it like this, right? In a court of common law, right? If you go against somebody in a court of common law, say, okay, right, perfect example, right? I had a business agreement with somebody, right? And in the business agreement with somebody, the dog that I had given them at a discounted price was placed at their home in order for them to keep it as their pet and for me to use it for my own breeding purposes to further increase the bloodline of my dogs. Now, in a common law court, which is the one that I was dealing with at the time, right? The thing is that they persisted in using that dog that I gave them as a pet to breed on their own and started generating their own form of income off of that dog under my fucking nose, right? And so when they tricked me into coming to their property in order to get the remedy, which was the money that they were supposed to pay me for the rest of the contract so that they could have sole ownership over the animal, what happened is they actually called the police on me and reported me for harassing them, and then I had to go to court and fight them in court. Because what they did was try to make it so that even though they were stealing my dog from me for like something around, I don't know, $20,000 less than what the value of the dog was to me, they were taking me to court for harassment because they called me over and tricked me into coming to their house and they set me up for it. Now, because of the fact that we were in a common law court, because it's a man versus another man in this issue, right? So because of the fact that we were in a common law court, when I was battling them in the court, it was only to keep it from me having charges pressed against me, but really it was their fault that I was there in the first place, right? So if we had done this in a court of equity, what would have been recognized was the fact that, one, this was a business partner that had a contract with me, and through that contract with me that they had through the business, I was only there to receive my remedy, which means that they would have been held accountable. In a court of equity, they would have been forced to pay me the restitution for the things that they had bred my dog to, and they would have had to pay me for the rest of the fees that they were supposed to be giving me originally. But because we were in a common law court, the only thing that was on trial at that court was the fact that I had gone to their property. So I had to prove myself innocent from having going to their property, because if they were able to get the restraining order on me that they were trying to, that would have made it so that the common law court was supporting them in stealing that dog from me. Do you understand the difference? If I was in a court of equity, what would have happened was the judge would have told them that they had to pay me what they owed me and that I would not be getting any orders pressed against me, and I would have got my restitution and they would have gotten their dog and everybody would have gone about their business. That's the difference between common law and equity. Now do we understand? If you get what I'm saying now, put a 1 in the chat. You get me? So there's a big difference between the brutality of common law versus the equitable answer of equity, right? Equity provides that everybody would have came out of that in a fair and just way, right? The fair and just thing would have been they would have had to pay me what they owed me, and I would have given them the contract for the dog so that they could have gone about their business. But because we were in common law, it was give him a restraining order for coming to my property to collect his dues. Regardless of the fact that I had a contract with him, regardless of the fact that he was doing bad business with me, all that would have happened had that court case actually been successful was restricting me from being able to go after him for further action to get remedy in the things that were owed to me. Yeah, the dog was a security, right? And we had a securitized agreement. We had a contract between us, but that was ignored because I was in a common law court. No, you wouldn't want... See, I didn't know about these things back then. These are the things that got me to the point to where I started studying these things. It was this exact court case that made it so that I needed to know exactly how this shit was being ran. All right? That's the thing that stirred my fucking shit into me going, okay, I need to figure out what the fuck is going on, because I brought it to notice that I had the contract. I brought it to notice that we were business partners. I brought it to notice that in the contract, he was supposed to return the dog to me had he violated any part of the contract. The judge gave no fucks. Because the court case wasn't about the contract. The court case was about the fact that I had gone to their property to retrieve my shit. So everything got ignored because I was in a common law court. That's the brutality of common law. So had I understand equitable interest at that time, and had I had an understanding of my security interest in the matter, I would have been able to conduct myself in a different manner, which would have produced the result that I was after. You get me? So basically, in the common law court, they helped that man rob me and tarnish my business. That's the difference between common law and equity. So, moving forward. Right? Section 2. Evolution of equity in England. The development of extraordinary jurisdiction of the Chancery Courts of England was similar in its cases, progress, and results to the development of the system of equity in the Roman law. As already intimated, in England, the king was regarded as the fountain of justice, and when any person conceived that he had been wronged, either in court or of the court, he had the privilege of petitioning the king for redress. The king, being unable to hear and determine all of these complaints because of their number and complexity, generally referred them to his chief secretary, who was called his chancellor. This officer was an ecclesiastic trained in the law and theology of Rome. Notice how we're talking about ecclesiastic. Now, where else do you find ecclesiastics? In the Bible, right? Pay attention here. So, in the law and theology of Rome, and was sometimes called the keeper of the king's conscience, right? See how it's dealing with conscience, right? It's not dealing with laws. It's not dealing with statutes. It's dealing with the conscience, right? When you're dealing with equity, you're dealing with things that are fair and just because they're dealing with what's right, not with what is cut and dry like you're dealing with when you're going into courts of law, okay? So, naturally determined remedy when this directed to adjudicate. Nope, that's not where we're at. This officer was an ecclesiastic trained in the law and the theology of Rome, and was sometimes called the keeper of the king's conscience. When thus directed to adjudicate the rights and determination the remedies of those petitioning the king for justice, the chancellor naturally had recourse to the civil law of Rome, being most familiar therewith, and also finding therein a diviner sort of justice, right? Divine justice, right? We were just talking about that earlier, right? And a simpler and more efficient form of procedure. Besides, the chancellors, who were generally very able and very learned men, were no doubt disposed to regard the England common law as barbarous, right? There you go. Common law is barbarous, right? So as a barbarous code compared with the Roman civil law, the chancellor, right? Civil. What is civil? Civil is people that are what? Fluent in contract, right? Didn't we just show you the definition of trust tells you that what? The first thing is that trust can only be dealt with in equity. Why? Because you're dealing with civics. The chancellor's office was one of the great trust and confidence. One of great trust, right? See how everything's starting to fall in place? He was the king's advisor and confidant, the chief member of his council and the keeper of his great seal of the state, right? When you're dealing with a trust, don't you have to have a seal? Right? He is spoken of at very early day as one who annuls unjust laws and executes the commands of a pious prince and puts an end to what is injurious to the people or to morals, right? So equity deals with morality. Equity deals with morality, trust, civics, ecclesiastic law, and is done by the conscience. What is right in your conscience? What is right in your heart? Right? You know when you're... See, in the person's heart, the one that was taking me to court, they knew that they were doing me dirty. Right? They knew that they had set me up to come to his house. He knew that he had a fucking contract with me, and he knew that he was trying to override the contract that he had with me by taking me to court to get a restraining order on me, because that makes it so that I'm no longer able to take action against him in the future. Right? That wouldn't have happened in a court of equity, because it would have been dealing with what is conscionable, what is moral. Morally and conscionably speaking, it would have been only right for him to have to pay me remedy or return my animal to me, because he would have made more than the money that he invested with me by actually by the breedings that he had done without my consent. Right? So I would have had remedy had I had gone to a court of equity. Okay? So, character of the first chancery suits. The chancellor, following the example of the Roman praetors, applied the equitable principles of the civil law to the determination of all suits referred to them by the king. The suits thus referred were generally applications to obtain redress for injuries and acts of oppression where from the power of the offender or for any other cause a fair trial in ordinary courts could not be had. Cases where there were fraud, deceit, and dishonesty beyond the reach of the common law. See what I mean? And the cases where the common law was inadequate to the requirements of justice. In those times of disorder and oppression, many were the appeals to the king by the poor and the weak for protection against the rich and the strong, the logical magistrates being often overawed, and many were the complaints of remedy at law. The king, unable to give personal attention to so many petitions, finally conferred upon the chancellor full authority to give relief in all matters of grace, as these applications for redress were termed, and from this period petitions began to be addressed to the chancellor themselves and not to the king. This delegation of authority was made in the year 1348. Okay? Now, I'm not sure what these cliff notes are for, but let's check them out real quick, right? Equitable jurisdiction, see post 15, Palm equitable jurisdiction. Let's see, the fact that the first chancellors were ecclesiastics, generally bishops or archbishops, accounts for and explains various words and phrases found in the old forms of bills, such as orator and one who prays. Doing contrary to conscience, the bishop being bound to act accordingly to conscience, and being also the keeper of the king's conscience, and your orator shall ever pray, etc. The full sentence being, and your orator shall ever pray for you, Barton Sutton Equity. Note, see also STO Equity Plain for... this inadequate conclusion is still sometimes used, and Snell's pure Chancery Courts of Tennessee represent the conscience of the state, and as the Chancery Court of England represented the conscience of the king. I'm not sure how that pertains to it yet, but we'll figure it out eventually, right? So where was I at? This delegation of authority was made in in the year 1348, and in the next 50 years, the equity jurisdiction of chancellor was clearly established. Right? The principles on which early chancellors acted. Right? That's what we're talking about right now. When the matters of grace were thus referred to the chancellor, he issued a writ. Right? Remember, you're going to have to learn about your writs, okay? Because as living men and women, you have to learn how to make your writs, all right? Now, don't worry, that's also part of this book, all right? A writ commanding the party complained against to appear and answer the complainant and abide by the order of the court. The principles on which the chancellor based his decisions were house of honesty, equity, and conscience. By conscience was meant those obligations one person is under to another to exercise that good faith the other has a right to expect, right? Perfect example. Once again, back to that dog situation. That guy was under contract with me, right? And under that contract, he should have either returned the dog or he should have had to buy the dog from me in full, which means that he would have had to pay me somewhere around $20,000 to have full ownership of that animal that came from my specific bloodline, right? Now, see, that's what they're talking about. The conscience was meant those obligations the one person is under to another. Right? Those are your contracts. That's contract law. Those are the things that you're agreeing on between each other. Okay. So had I put him into a court of equity and had I brought out the fact that we already had a trust agreement between each other, that should have been enough, but I didn't know how to alliterate these things or put these things into the court properly at the time, right? This is the thing that stirred me into this and actually got me studying down these things, was how this court had actually pretended like I was the one that was at wrong for him inviting me to his house to get remedy, right? So, good faith and one other has a right to expect. On an application to Parliament for redress, the petition was referred to the Chancellor with the command, let there be done by authority of the Parliament that which right and reason and good faith and good conscience demand in the case. Right? What they're saying is exactly what I was telling you. Was that, they would petition to make sure that, even though the court had even though the common law court had already said that this gave them a bullshit ruling, they were able to take it to a court of equity where it was going to be forced to do what was actually right for the people that were involved in it, because equity guarantees justice for all parties. It's not just one end. Right? Equity makes you actually look at both ends of things. If you pay attention when you go into a court of law right now, it tells you that there's no truth that will be tried here. Because it's not about that. It's about the action. Right? So, let there be done by authority of the Parliament, which... Oh, we already read that part. Well, whatever. Let there be done by authority of the Parliament that which right and reason and good faith and good conscience demand in the case. Matters of grace being thus brought before the Chancellor as the keeper of the king's conscience, and he being required to do justice in the king's name, he felt under no obligation to determine the rights of the petitioners by the law from which they had fled to the king for relief. See, when the law is out of order, you go to the king. Now, when you're acting sovereign, you're acting who? As king. Right? So when you're acting as king, you're acting as the authority, which is why you have to have the trust set up, because the king operates from the trust standpoint, which brings you into your courts of equity. But you have to learn how to express yourself as the sovereign, as the living man, as the one that is under their own jurisdiction. That way, as king is what you're doing with the questions. You're operating as the king. That's why you're not there to answer questions. You're there to ask questions as king, asking. Okay, so, and for reasons already stated, the chancellors at an early date adopted the equitable principles and simple procedures of civil law of Rome, adopting them with wisdom and prudence. To the emergencies of the particular cases, the matters referred to them being matters of grace and of conscience, and the chancellors felt bound to decide the cause according to conscience, right? The jurisdiction of the chancellor being thus established upon grace and conscience, and his judgments being in the name of the king and by his authority. Whenever the courts of common law were inadequate to the demands of justice, the party unable to obtain relief therein would have recourse to the chancellor, who in his court, called the High Court of Chancery of England, undertook, like the Praetor of Rome, to administer, right? Administers, right? Isn't that what they call your so-called judges right now? The administers, right? Praetor of Rome, to administer an equity not found in law, himself determining all questions both of law and of fact, and rendering a decree adapted to all the exigencies of justice. Okay, so in order for you to find justice in a court of equity, what they're going to do is weigh out the facts. The same facts that were being ignored when old boy took me to court to try to get the restraining order on me are the same facts that would have been actually taken into consideration if we were dealing with a court of equity at the time, right? So, the common law as compared with the civil law. The common law was then utterly incapable of doing complete justice in many cases, and in not a few cases. Now, where do you get common law from? Common law is where you're dealing with when somebody brings something against you, right? When another living man, right? You don't get common law when you're dealing with statutes, codes, and ordinances. That's not where you find common law. Common law is found in civil courts, okay? Now, in civil courts, you can invoke equity if you're dealing with matters of trust, or if you actually know how to invoke equity when you're dealing with it. But you won't get it if you don't have a trust set up, because equity is only found in trust law, the ecclesiastics that we were talking about earlier. Okay, so when you're dealing with these things, what you're actually wanting to do is, when somebody brings you into a civil court, you want to go in as the registered agent, because the registered agent is going to be able to invoke equity. You understand what I'm saying to you? Like, when you go and register your estate, you're going to have an agent that is created. The first one that is created is your executor. Now, after you have the executor of your estate, then you delegate the fiduciary, then you delegate the trustee, then you delegate the beneficiaries and the grantors. Okay, these are the different hats that you can wear when you're going in court, but you don't have to tell them which hat you're wearing specifically. All you have to do is tell them, I am the registered agent for the estate of, and then fill in the name. Right? And that will automatically, once you start speaking these things to the judge, they're automatically going to start realizing that you're already invoking a court of equity, because of the way that you're presenting your arguments. See, the other person, more than likely, the other person's not going to have shit of fucking sense of what you're talking about. They're not going to be able to make any sense of it. But once that judge understands that you're coming to this with clean hands, and that you're coming in there. Now, what do they mean by clean hands? Clean hands is what I would have been considered to have clean hands. My business partner who was doing me dirty would not have had clean hands. He would have not been able to invoke equity, because he tried to use the law to avert being part of the contract that he was bound to, right? So I would have had clean hands, because all I was doing was going to get remedy for my contract that was already in play, right? So my clean hands would have outweighed anything that he had to say, and doing justice in the form of equity would have gotten me the justice that I was after, because by speaking myself into a court of equity, that would have actually pulled all of the jurisdiction onto my fucking benefit. The judge would have been on my side of things no matter what would have came out of his mouth, because I was the only person that was doing good business there. You understand? So I would have had justice served had I been able to articulate myself in the proper manner. Yeah, sound mind and clean hands, exactly. Black and white film on the text of the page. I don't see what you're talking about. I don't see what you're talking about, but I'm going to move along. So, now, So common law was then utterly incapable of doing complete justice in many cases, and in a few cases it furnished no remedy or relief whatsoever. It had certain rigid molds or formulations, into some of which were every cause of action had to cost, and if the cause could not be run into any of these molds, there was no redress, and it could be run into one of the molds, only such redress as the formula gave could be had. Regardless of the equities of the case, the real rights of the parties, the fictitious formulations and arbitrary technicalities of the common law and its dialectal refinements were inexplicable and incomprehensible jargon to the public. Right? Legalese bullshit. So, and often a costly mockery of justice to the litigants. Those who asked for bread were often given a stone, and those who applied for a fish sometimes received a serpent. Okay? This is Suits and Chancery by Henry Gibson. What up, Jazz? Oh, you can use all of this. You have to use this with the Rothschilds because the Rothschilds are dealing everything from a trust standpoint. Hey, Serpent Traveler, you've been saying a lot of nonsense on my posts. Leave it out of my lives, please. The fictitious formulas and arbitrary technicalities of the common law and its dialect refinements were inexplicable and incomprehensible jargon, right? That's your legalese, right? It was jargon to the public. The people of the public do not have a fucking clue what the lawyers and the attorneys and the fucking judges are actually talking about, right? It all gets confusing and people get lost really quick all the time, right? So, equity, on the other hand, disregarded forms, ignored fictions, subordinated technicalities to the requirements of justice, and indulged in no dialect refinements. Its pleadings were simple and natural, and its doctrines were founded upon the eternal principles of right. Right? Right? Where do you get your rights from? Your unalienable rights and things, right? That's found in equity. As interpreted by a lofty Christian morality, its great underlying principles, the constant sources, the never failing roots of its particular rules were the principles of equity, justice, morality, and honesty, enforced accordingly to conscience and good faith, and so adapted the requirements of each case and the complications of business's affairs, and the rights and the duties of all of the parties were fully determined. Realize that when we're dealing with equity, equity is the one place where you can actually go in and speak English. Right? You can't speak English in a statutory court. You can't speak English in a common law court. Because everything is based off of legalese, litigation, paperwork, and fucking bullshit, whatever the person says. Like, basically, it's like this, right? When you're dealing with common law, when you're dealing with statutory law and things like that, whatever's on the paper is the only thing that can be heard. Which means that you have to be fluent in their language in order for them to be able to acknowledge the things that you're putting in play in the first place, which makes it very complicated because then you have to learn a whole new form of language just to be heard inside of that courtroom. And if you don't put it down on the paper, they don't have a fuck, they don't give a fuck what you say, right? They can't hear the living man. They can only hear what's on the paper. You understand? So if you're not fluent in their language of legalese, then you're always going to get lost in a litigation, and they're going to be able to entrap you using that because you're not going to have a remedy. You're going to have a result. There's no justice in these courts. There's only actions that are written in stone, right? Equity is the only place where you can actually go in and have a comprehensive conversation between both parties and have it weighed out and judged fairly, where the judge is going to be on your side of things, not on their side of things, right? So lawyers are not welcome in a court of equity. They're useless. They have nothing to say because everything coming out of their mouth is what? Legalese, is bullshit, is that jargon that they were talking about. You understand? So lawyers get booted. They get sat down. The judge tells them, don't even fucking speak. This got nothing to do with you, because your conversation now becomes a conversation instead of an actual fucking, instead of the actual bullshit, right? Well, Johnny, that's what we're talking about right now, right? If you were in here earlier, what you would have found out is that the court of equity is the thing that deals with your rights, right? Equity is the only place where you're going to get a remedy under your unalienable rights. You're not going to get remedy on your unalienable rights in a court of common law. You're not going to get that in a court of jurisprudence, in a statutory court. You're only going to get that in a court of equity, right? So you have to keep these things in mind when you go into these courts. If you don't want to be in those courts in those capacities, you can take a common law court and turn it into a court of equity by submitting the proper paperwork and delegating these things so that the judge knows that where you're coming from. If you can submit it on the paper, the judge will then hear it in that say. It's your duty to tell the court what kind of court that you're going to operate in. You set your jurisdiction when you go into the court. It's what paperwork you send in to them, right? You send in the acknowledgement of the trust, which automatically makes you the living man, which makes you the agent, which gives you the access to the equity. If you don't do these things, then you're seen as the ward of the state, and under the parents' patry, they're going to treat you as such, and you're going to be seen as a minor and somebody that's incomprehensible, and they're just going to run you through the floor. Yeah, exactly. You have to express it. Right? So if you don't allow yourself to understand how to express it in the first place, which is what we're going to be getting into further along in this book, it's going to make it so that you're always going to be getting stuck into the wrong type of court. Right? Court isn't, look, first off, let me explain something to you. Court is not the building that you go in. Court is the paperwork that you submit. When you get a notice from a court telling you that you have to appear for a court date, you're supposed to respond to that. See, people of honor and good faith that operate with clean hands are going to respond to that, because people that are honorable, they do what? They give you a phone call before they come to your house. They give you a notice to let you know that you're going to appear, right? So when you're dealing with these courts, if you don't give them notice, you're automatically under their jurisdiction. You're now going to be going and dealing with common law or statutory law. So when you're dealing with a court, you have to give notice to agent. Notice to agent is notice of principle, right? What is the principle that you're after? You're under equity. That is your principle. You want to put them on notice that you're coming from an equitable standpoint. That way, when they deal with you, they're dealing with you in a court of chancellory instead of dealing with you in a court of statutory. Because statutory courts are going to be what? Very dry, very cutthroat, and very damaging. Right? So notice to agent is notice to principle. Once you express the fact that you're the agent of the trust and that you will appear by special appearance to gain remedy and recourse for the actions that your trust is being trespassed with, you're then moving it from the court of common law or statutory jurisdiction into a court of equity. Right? The court is only the paperwork. It is not the building. It is not the people. It's the paperwork. And so as the living man, when you receive that notice, you respond to it to give them notice that you're going to present yourself. Once you've given them notice that you're going to present themselves in the capacity that you're moving in, that automatically shifts the jurisdiction of the court to the one that you're looking for, rather than the one that they originally thought, under the assumption and presumption that you were going to remain under. Because once you've established that you're the party with the equitable interest, you then move yourself to a position to where you're operating from the trust, which is where your rights are invoked. You see a lot. Hey, put a 1 in the chat if you see people going into a court and trying to argue their rights with a judge and failing at it. Right? You see that all the time. Why do you think you see that all the time? Because they didn't express it prior. No, you will not win in those administrative courts. They are not there for you to win. It specifically tells you in all of those courts, no truth or fact shall be judged here. You get me? No truth or fact shall be judged here. It says it on every last one of those courts. Now, if you conduct yourself properly, if you set yourself as the registered agent, if you put them on notice of the principles of which you will appear by, you will find that most of the time they'll just dismiss it right off the bat, because when you're putting them on notice of your principles, you're also going to include all of the infractions that they are occurring and that they are trying to do on your securitized agreements. And by doing so, they're going to either dismiss that shit before you even have to deal with it, or they're going to allow you to come in there to see if you actually know what you're talking about. Because once you put them on notice, the thing is that you don't wait for them to respond. That's where most people fuck up at. That's where I fucked up at when I was dealing with it. So I'm letting you know, okay? The way that I fucked up when dealing with my court case when I was dealing with them was that when I put them on notice, right, and they received said notice, I was supposed to perform after they received the notice, because I gave them a time period for them to respond to that notice. I no longer had to show up for that court date because of the things that I put them on notice of, but it was because of the fact that I didn't pursue it further after I had told them exactly what was supposed to happen that made it so that they knew that I wasn't fully prepared. This is why I tell people, do not fucking listen to people that try to teach you about these things in one setting, because these are things that they're going to leave out, that they're not going to know about, or people that haven't done these things aren't even going to be able to express to you. The place that I failed at when I was dealing with my court case was after I gave them a 10-day window to respond to things, which is the proper amount of time. Once I had done that and they didn't respond within those 10 days, I should have taken the notice that I had given to them and pushed it on to another court and filed a suit against them, because it's their tacit agreement by not responding to it that's accepting the order that I had given them. And because of the fact that I didn't realize that during that time, they were able to push forward with the case, because I never pursued the actions. Okay, so this is why I keep telling you guys that, you got to watch out for these people that claim to be gurus, that teach you, that say they're going to teach you how to do things, and that you need to get yourself familiar with this yourself and study this yourself. Is because if I had known that then, I could have then taken the fact that they never responded to my notice as their acceptance of my notice, which would have made it so that I could have pursued them further and shut down their whole entire court system, had that judge debarred, had the fucking the prosecutor debarred, had the fucking sheriff and the county clerk and the Supreme Court judge that I had also put on notice of all of these things. I could have had all of them wrapped up in one mean ass court case. But I didn't know at that time, right? Oh yeah, I can still bring claim now, but I had to get more familiar with it to get to the point of understanding it and for me to be able to overstand it. Now that I see the things that I did wrong in that, I can still pursue that and finish doing what I was doing. All I have to do is send it into the other court, the court of claims or the appeals court, and send that information into them, see, that's the reason why I haven't taken action yet, because I'm not 100% sure which court it is that I'm supposed to send it to next, right? But because of the fact that they didn't respond to it, and because of the fact that I didn't push forward with it, they're still sitting there on their positions. But I can knock them off their fucking seats, from the Supreme Court judge to the Bar Association to the state judge that I put on the notice, to the prosecutor that I put on notice, to the clerk that I put on notice, to the Supreme Court clerk that I put on notice, to the Bar Association, to the mayor, to the governor, and the Secretary of State. All of them had notice of everything that I wanted done and that I wanted my remedy for the court case. You understand? So now I have to, I have to go after each one of them individually. Right? And that's why we've created the federal court. You see where I'm going with this, Johnny? We actually created a federal court because we didn't want to have to deal with their courts anymore. Right? So I've already got my litigation being looked at and overviewed by a couple of people. The one that created the federal court for me, she's looking over my documents to make sure everything's solid. And she's going to get back to me and let me know what I need to do for my next steps with that. Right? So I'm in the process of it. And once I'm done with it, we're going to put a writ of quo warranto on that fucking county of Prairie, Arkansas. And we're going to shut down the government in the whole entire area. We're going to get everybody out of jail there because everybody's rights have been trampled and everybody's under that same fucking court and everybody's under the same officers and the same fucking judges and the same bullshit that I had to put in action. So now that we have a federal court of our own, my friend that created that federal court, that is the judge of that federal court, is reviewing my case. You understand? So we're putting all of these things in motion. Okay, well, that's why I come and talk to you guys about this publicly. The reason that, you see, this is the other thing, right? Now, how many people in this chat have been following me for a while, and I keep telling you, when you do your studies publicly. Do you notice how there's other people in the chats that are very successful with the things that they do, that are sitting here giving me the other keys to the remedy that I need? Right? This is why I tell you guys to study publicly. I don't give a fuck how many people around you think that you're crazy. I don't give a fuck how many people around you fall back from you in your life. You're trying to accomplish something. Do it publicly so that other people can see, because once they see that you're actually putting in the actions and that you're not somebody that's just fucking sitting there twiddling your thumbs waiting for somebody else to do it for you, they're going to come forward with the things that you need to complete your goals, because we all want to help each other. But as long as you stay quiet, as long as you keep it in the private, as long as you keep it to yourself, you're going to be stuck. Because it takes a fucking nation. You understand? This is how we stand together. This is where your unity comes from. This is where you find the people that are on the same mission that want to get these things accomplished. So when I tell you, like, for all the people that are in here that have access to my library, that are studying the things in my library, every day that you're studying them, make a post about what you're studying. If you make posts about what you're studying, it's going to draw in the people that have already completed it. They're going to want to help you, because unlike most people, you're actually taking the time to do it. See, the reason that you don't get me to answer you in my inbox about these things, the reason that I refuse to talk to you guys about it, is because you sit there leaning on my words and my things the whole entire time without doing any of the work yourself. And I can't help you that way. And there's so many people that ask me questions that I give answers to that's literally just a waste of my time. I literally sit around burning up hours of a day answering questions for people that are never even going to pursue the actions that are necessary to complete these things. Damn, Johnny, that was like fucking a year or two ago. You get me? So when you're studying these things, make sure that you're doing it publicly. Make sure that you're asking questions. Make videos asking the same questions that you think that you have for me. Make a video. Hey, look, I'm studying this. I've learned this, but I don't understand this. And I guarantee you, that's how I found a lot of people that taught me a lot of the things that I know. Is because of the fact that as I was going through studying sovereignty, as I was going through studying the secured party creditor, as I was studying how to create the trusts, as I was doing these things, I did it publicly. That's how most of you ended up following me in the first place, was because of my public studying. But what you're missing in that is all of the people that are already successful, that have already completed these things, are the ones that came to me and said, hey, look, I see what you're doing. Here's this that you're missing. What's not okay? What do you mean this isn't okay? This is exactly how you need to do these things. If you don't do these things, you're never going to be able to complete it. Do you realize that it's taken years upon years for me to actually understand these things? Like, I've been studying this shit for 5 years almost. I don't know what you mean by the Draxonian. You guys keep giving these people names and titles and ideas that make you think that they've got some type of special thing or special this or that, and you guys got to let that shit go. It's all propaganda made to keep you in fear of getting the things that are due to you. Right? Now notice how, as I've been reading this, right, because of the fact that I've been studying this for so many years now, as I'm reading this, I'm able to make it make sense for you so that you understand what they're talking about when we're going through this. Right? Yeah, you gotta stop giving people these titles and these names. They have no authority. They have no, like, don't fall for this reptilian shit. You're a reptile yourself. If you don't believe that you're a reptile, look at your skin under a microscope. You have scales. That doesn't make them any more special than you. You're a reptilian just like they are. Matter of fact, you were a fish. You grew up in underwater. You were born in water. Stop letting people give you ideas that make you think that somebody's different than you. They're not. That's what they want you to believe. And if you keep falling for these stories and things that make you, that you're giving them power that they don't deserve and don't need. You don't know us, bro. You don't even know what you're talking about. You're calling people draconians and reptilians and all kinds of shit. Oh God, man. Look, bro. Guy, look. Yeah, it's it's the big scary game. Like, bro, all that stuff that you're saying is pure propaganda, my guy. Now look, if you pay attention to the things that I'm teaching you right now, none of that shit is going to matter because you'll always be able to get your remedy. So just throw that shit out the window. Tell me how that idea is helping you when it comes to getting the things that you want done. What's the proper way to start learning this? I have simple things, bro. You can get the Meet Your Straw Man book. This will give you a good breakthrough into it, right? Your UCC connection will give you a great start into it. I have a library that you can get access to for a minimal $75 donation, which includes all of the books that I read from, all of the things that I talk to you about. You get me? And that has, videos inside of it and seminars inside of it that break these things down for you so that you can start to comprehend them. It also has all these books in it too. Your Meet Your Straw Man, your UCC Connection, all those, your Meet the Pale, Behold the Pale Horse, your Magna Carta, your common law books, your fucking trust books, how to set up your trust, how to establish and fund your trust, how to create your church, how to create your unincorporated business. I have all the books on all of this stuff. All right. So, if you need help beginning with this stuff, you can get access to my library. It's a minimal $75 donation. It'll probably be the best investment you ever made in your life because those investments are what are fueling the things that we're putting together to put this into action, right? Like those donations that I'm taking right now are going directly into formulating this federal court that we created and formulating this registration that we've created for people to actually start getting easier access to creating all of their trusts and things. The library, I ain't gonna lie, Johnny, it's not very organized. I probably should organize it at some point, but the group that I put together, it has instructions on where to start in the library. It gives you good instructions on what to start with. That's how I put it together. It's a 34 gig library. There's so many documents. It's not like all these packets that people pass out. Okay, I've got about somewhere around 20 grand invested in it so far out of my own pocket and probably about 3 or 4 grand invested in it out of people that have donated towards it. I take the donations and buy like books that people can't find and stuff like that and pay people that have books that I want on file. I'll pay for like a book set to be digitized, like I have no problem paying people to have books digitized for my library and shit like that, because that's what happens with the donations, is they're basically there to make it so that we can all contribute towards the library instead of just me. Yeah, this is a good book to start with, but the reason that I don't say that this is a good book to start with is because most of people aren't going to understand the litigation of this book. Unless you've been fluently hearing people speak and studying and looking up words that have to do with legalese, a lot of people are going to get lost trying to read this. You get what I'm saying? So, you know, this is more, it's a beginner book, but it's like an advanced beginner book is the best way that I can explain it to you. Right, this is a book that you want to start reading after you've already started, like, you know, studying the Black's Law Dictionary for a couple of years and started looking up definitions of legalese words and things like that. Because when you get to reading this, you're not going to, you're without being fluent in those things unless you get this and pair it with a Black's Law Dictionary. Right, if you pair it with the Black's Law Dictionary and look up the words that you're reading as you're going through these things to make it make sense, yeah, by all means, this would be a good start. But unless you're already fluent in legalese, a lot of this is going to go right over your head. You get what I'm saying? So I'm not trying to discourage you from it, but like if you watch like the Rourke seminars, right, if you go into the library, right, all this is in the 2025 folder. Okay, here's your Treaty on Suits and Chancery, your American Jurisprudence, and your Negotiable Instruments. These are the books that we're going to be getting into on the profile for the next couple of months. Okay, yeah, that's the thing. That's what led me to get this book. The Treaty on Suits and Chancery was because Rourke mentioned the guy that actually wrote it in one of his videos. Right. So, see, I've got see, there he is right there. Right, I've got his whole entire week-long seminar. And then I also have Ron Gibson's land patent book and his seminar. Yeah, I know, Johnny, I paid for it. That's why I tell people, if you bitch at me about $75, then I'm not even going to give you access to my library, because fuck you, I already paid like over 20 grand for this shit. Okay? I got the whole entire seminar right here. Plus, I also have Ron Gibson's seminar. Because right when I was listening to David Straight's stuff on YouTube and shit like that, he kept mentioning Ron Gibson in his book on land patents. Right, so I have Ron Gibson's land patent book, and I have the seminars and the webinars that go with it. You get me? Yeah, the Moorish American titles, right? How to proclaim your Moorish nationality. You get what I'm saying? Right. Everything. Everybody should claim their Moorish nationality. Every last one of you is born in Morocco. You should register yourself as a Moroccan. If you don't register yourself as a Moroccan, you don't have the highest form of title in this country. Now, whether you go through the Moorish Science Temple to do it or not, you know, that's up to you. There's a couple different ways that you can go about it. But, you know, that's the highest form of authority in this country. Yes, you're born in Morocco, okay? The word America means Morocco in the Berber language, the original language of the Moroccans. Do you know that the one that's on the map right now is not Morocco because it's pronounced Morocco? That's an English word. That is not the language of the people that spoke it. That is a new form that was established after the French Revolution. Miller's seminars? No, but if you tell me about Miller's seminars, I will definitely go and look into it. If you tell me about Miller who? I got Ron Gibson stuff, I got Rourke stuff, and I started getting Patrick Devine's stuff, but I found out that Patrick Devine had, like, all of his videos are on YouTube, so there's no point in me putting them in my library. Oh, Carl Miller. No, I haven't found any like exclusive seminars of Carl Miller's, but since he's on YouTube, I don't need to put him in the library. I don't need to put David Wynn Miller in the library either. See, anything that you can find in the public, you don't need to find in my library. You get me? The library just has things that are a little bit more exclusive. You get what I'm saying? And thank you for actually thank you for saying that. When I get done with this live, I'm going to have to go into the library because I keep forgetting that I wanted to create a link in my study group that gives a link to each one of the pages on YouTube that has those videos on it. See, It was when it was Miller that it was Miller that gave me the information on the suits and chancellory, I believe. I think it was David Wynn Miller that mentioned it. Because this is George Gleason, right? See, everybody that, in all of those videos, if you notice, they'll mention certain people in those videos that they studied with or that they partnered with when they were learning things. And so every time that they mention a name, I would go and pause it and try to find anything that I could that had to deal with that person and slap it right into the library immediately. Yeah, I heard about Russell J. Gold, but I haven't actually looked into his works yet. Right? I haven't gone down that route yet. A lot of times, see, the thing is like, although these are great references and great people to study under, my thing is once you give me the keys to something, I put it in the fucking ignition and I go. Right? So my thing is as soon as you tell me about something, I'm going to want to go and do my own digging. I don't really necessarily want to go off what other people say specifically. So I like to go and do my own research into it. And if you know, I find something that I get hung up on, then I'll go back to the person that I originally found it from to see what they're saying about it. That's pretty much how I do my research, you know. Because, you know, we're supposed to be sovereign. You're supposed to be self-taught. And yes, it does help to have others help you and stuff like that. But, you know, you got to verify things for yourself. And there's no better way to do that than what? Go and look at it for yourself. What Rourke seminars? Sorry, my handwriting's a little fucked up because my hand's jacked up. Boop. He had like a week-long seminar. Let's see, Rourke day 1. Yo, this shit right here cost me fucking $4,500. This seminar by itself cost me $4,500, yo. Just this one set of fucking videos. Sorry, it takes a second. Let's turn the volume up real quick. Yep.
So we started down in the morning, talking about a little bit about me, a little bit about how I met Eric.
But it's about as far as I'm going to go with it because TikTok starts sending me notices about playing videos. They don't like it when I do that. They threaten to flag my shit. They're like, you can't show that. I'm like, all right, my bad. Right, so that's Rourke right there. Now, with Rourke goes the Rourke manual. Right, this is the manual that goes with those videos so that you can follow along with the class that he's having. All right, that's his whole manual that comes with your instructions and all the stuff to operate the way that he tells you to. All right, so it was a whole package that I got. All right. Now, luckily for me, I'm not the person that violated the non-disclosure agreement because I didn't have to sign one to get this. And because of the fact that I didn't sign one to get this, I get to put it in my library where people can gain access to it. Now, had I been the person to sign the non-disclosure agreement for this, I would be fucked if they found out that I was doing this. But since I'm not that person, I can't be held liable for the fact that I purchased it because it's my property that I purchased fair and square. Same thing with... where's that fucking keyboard at? Bink. Bink. Ron Gibson. Oh yeah, it'll help a lot, Cinnamon. This is exactly why we're going over these things, okay? Because as you know, there's no point in me speaking to you guys about your trusts and no point in me speaking to you about operating in the private if you don't know how to conduct it, right? That's the part that everybody fails at. And so while everybody's always trying to ask me to give them seminars on how to do all the paperwork and shit, guess what? We're going to do this for free. Every Sunday, we're going to have a class right here on TikTok where you can sit in and you can study these things with me as I refresh myself and get more fluent with it so that I can be more efficient with it. So you can come in here on TikTok and chill with me on Sundays, and we're going to have these classes every Sunday. And until that little notice pops up on my TikTok telling me that, with that little puzzle piece telling me that I've been live for too long, we're going to keep on going. Okay? Trey, I'm gonna boot you out of this live, bro, because you seem to be always talking about nonsense. So you gotta go for this live, bro. Like you're basically just fucking a distraction to people, and it's kind of annoying. So I'm not mad at here. You can stay if you want to, but I'm gonna mute you. What time do I think? I pretty much get up around noon on Sundays, because I pretty much spend like all Saturday night beating the hell out of people on Fortnite and fucking video games and stuff. And don't mock me for my video games. You know how many people that I've talked to about these rights that are actually fluent in this shit that I've played fucking video games with, that I met online on video games? Like, it's amazing. It's just like, you have no idea how many people, like, you know, in video games keep your mind sharp, okay? So don't judge people for playing video games. All right. So, I wake up a little bit late on Sundays because I'm usually up having fun all Saturday night, all right? So, motherfucking, the law of mankind. Inbox me that. Inbox me on the law. Inbox me so I remember it so I can go look for it. You too, guy. You just been in here speaking nonsense the whole time too. Oh wait, no, cancel. I don't want to block you. You gotta be muted for this shit too. I'm not gonna let y'all talk if y'all just gonna talk nonsense in here. You see, we're trying to have adult fucking conversations in here, and y'all just want to speak on nonsense that doesn't help nothing. Eastern Central Time. Yeah, most people think that the story of Queen Khalifa is a real thing, but it's not. It's a made-up fucking story. But that's a whole nother subject in itself, okay? Like, a lot of people believe in a lot of fairy tales, like gods and goddesses and motherfucking stories of, like, like the Emerald Tablets. That's the biggest fucking lie that's floating around social media I've ever seen in my life. And people buy into that shit and listen to people that think that it's real and try to convince people that it's real and shit. And it's astounding how many people fall for that shit, because why? They don't do research. It only takes very simple research to find out that the guy that claimed to have found the Emerald Tablets never fucking showed it to anybody in the public ever. So what are these green stones that everybody's passing around saying are copies of the Emerald Tablets? That's what I'm kind of wondering. How do you get exempt from taxes? Here, let me tell you something, right? Quit that job and have them rehire you. Tell them that you want to redo your tax forms. Look, let me show you something that's funny about taxes. Because I've never paid taxes at any job that I worked. Any job that I had when I was fucking working jobs and shit like that, I never paid any taxes. You know why? Because I always wrote exempt on the paper. That's a contract. That's your securitized agreement. You can alter that shit however you see fit. Write exempt on it. They took the spot out that fucking says for exempt. But if you remember, when they had that exempt spot, they would say, if you believe you're exempt, check this box. And nobody would check it. That's how easy it is to be exempt. Oh, I love this tablet, man. It's the most handy thing that I've ever got. All right, this is something I got with the donations. Was a new tool for me to teach with. But yeah, literally the only reason that you guys pay taxes on your jobs is because you never check off that exempt box. Because you get confused, right? They say, if you believe it. If taxes are voluntary, then you have to believe that it's fucking voluntary. Right? They tell you all the time, taxes are voluntary. But yet when they asked you if you believe that you're exempt from taxes, you didn't say yes. You just You just went forward with it and gave them your money. You did that. Now, because of the fact that you didn't write or didn't fucking check that exempt box, you're now obligated because on your contract, you agreed to it. I have never in my life, when I was working jobs, I never in my life didn't put down that exempt. Never in my life. For any job. And you know what? The IRS never came after me. And I somehow still got tax returns. I don't even know how that part worked out, but they still gave me money at the end of every year. Explain that. Is this sovereign citizen talk? No. This is your rights, your obligations, and your exemptions. We're just talking about taxes right now. And why you're paying taxes on a fucking job that you could have not been paying taxes on. So how is that sovereign citizen talk? You can't be sovereign and a citizen. You can be one or the other. You can be a sovereign or you can be a citizen. See, that's how I know that you don't know what you're talking about, because you just came in here with an oxymoron and spoke it into existence like it was real. That's what the federal government taught you. Because anytime you look up a sovereign citizen, you're going to see somebody go into jail. You know why? Because anybody that they labeled a sovereign citizen, they labeled it that for a specific reason. The specific reason was because if you're going to be sovereign, you have a responsibility of putting everybody on notice of who you are. And if you don't put people on notice of who you are, you're going to get pulled over under the assumption and presumption of being a citizen, which will indeed, in fact, get you put in jail. You get what I'm saying? Does that make sense? Like, think about that for a minute. Like, think about what you just said, right? If you're a citizen, that means you're under the parents' patry, which means that you have a guardian, which means that you're seen as a minor, and a minor is not somebody that is young. A minor is somebody that is oblivious to civics, law, and their rights. That is what a minor is. Would you like me to show you? Hey, greetings, man. Welcome. Let me show you. We'll just pull out this trusty dusty Black's Law Dictionary. This is a place of education, my friend. Where is it? I know it's right in here. Let's see. Ministerial. Minor, someone who has not reached the full legal age, a child or juvenile, also termed infant. Adults, emancipated minor, a minor who is self-appointed and independent of parental control, USA, a result of court order. Right? Now, where's that also C part? Hold on. Not reached full legal age. See, this is why you don't want the new fucking Black's Law dictionaries. Now, oh, I'm sorry. The word is minority. Minority. The quality state of conditioning of being under legal age, although at common law, minority lasted until the age of 21. Today, by statute, the age is generally 18. In Scots law, legal minority begins at the age of puberty. Until then, a person is a pupil. Also termed infancy, nonage, immaturity. Right? Immaturity, there you go. A group having fewer than a controlling number of votes or similar rights. Right? Now, why is a minority somebody that has a group that is different, similar rights? Right? a group that is different in some respect, such as a race or relief or belief from the majority, and that is sometimes treated differently as a result, a member of such a group. Some courts have held that the term minority in this sense is not limited to a group that is outnumbered. It may also be applied to a group that has been traditionally discriminated against or supposedly suppressed, and even if its members are in the number of minority, right? You see, this is why you want the older versions of this book, because the older versions of this book have a different definition in it than the current ones. And you need those old definitions in order for you to see what they're really talking about when they mention these things. Okay? Now, if you don't understand the parents' patry, right, it's where you're being treated as a minor. Right? I'll show you what I mean. Let's go to this. Let's see. Plus. Parens Patre. Well, that's not going to pull it up. Oh, there it goes. Parens Patre is Latin for father of the nation. In law, it refers to the public policy power of the state to intervene against an abusive or neglected parent, legal guardian, or informal caretaker and act as the... All right, let's see. The government or any authority regarded as the legal protector of citizens unable to protect themselves. That's what the judge is looking at you from. Now, if we move forward, right? Shit. Doctrine of parens patri. Bloop. The doctrine of parens patri is a legal principle where the states act as a guardian for those who cannot care for themselves, particularly minors and individuals with disabilities. This essentially means the government, in its role as parent of the country, steps in when families fail to adequately protect or provide for their members. Now, what you have to realize about this is that you're under parens patri. That's why when you go into the courtroom, the judge assigns you somebody that is legally comprehensive, because you're seen as a minor by the fact that you don't understand the things that are being spoken in the legal sense. Oh yeah, the Bureau of Land Management, bro. You know how much fucking shit I found in my family? I think my great grandfather owns like a quarter of this nation. Hey, what the fuck? Look, check this out. What's this shit? Last name, Smith. First name, John. Oh, motherfuck. Hold on a sec. Where's that keyboard? Yeah, I just discovered this the other day. No, wait, go back. I don't want it in Alabama. I want it across the whole country. Go back. Watch this shit. Any state. Boop. Now, this is the shit that makes you want to punch people in the face that try to convince us that we're African Americans. If we're African Americans... Oh, shit. What just happened here? Oh, let me go back one. I must have did something incorrect. Oh, there it is. Look at that thing before the M. Pink. Pink. Dun, 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 dun. Yeah, see, the thing is that my great-grandfather, one of the founders of Black Wall Street, was also the president of the bank there, and was also my grandfather was the sheriff. My great-grandfather was one of the founders, and he was the president of the main bank of Black Wall Street, and he was also one of the people that put the original railroads into Black Wall Street. So John W. Smith, although there might be a few others, right? I haven't really found too many others that are naturally born from this nation, but His name is on all these documents. Go all the way across the entire fucking country. And I looked, and there's not too many people naturally born from this nation that were carrying John W. Smith at that time. There's like one or two others, right? Now, these are John M. Smith. Where's John W? Hold on. Smith John, right? But I don't count those ones. Where's John W? Hold on 1 second. Next. Hey, wait a minute. Let me go back to that search again. Let me see something. Something's wrong here. No wonder. Sorry about that. Ready for this shit? So yeah, when you get access to my library, you get access to all those videos and all those seminars, and that's just the tip of the iceberg. Notice how there's 27 pages of John W. Smith? Literally. Every single page. Now, whether this is because he was helping people set things up, but what I've noticed is that, yeah, everything's in the meridian. Most of the meridians are specifically deriving from specific tribes, right? The Choctaw, the Chickasaw, those are both the tribes that keep popping up under the meridians. Talk to me about what? I think Her Free Will already has access to my library. I think. Maybe. I don't know. Right? But if you notice, like, there's 27 pages of fucking property in all the different states that's in my fucking grandfather's name. Arthur C. Parker. I'm not gonna lie to you. I'm not the best with pulling my family tree together, but I just found one of my cousins because of the fact that I mentioned my great grandfather, and he was like, "Hey, that's my great grandfather," and we just found each other the other day. So he's taking a look at my family tree and altering things in there and adding stuff in there. Okay, so you know, I'll be able to get back to you on that after that, but I'm not the best with that Ancestry.com shit, because I don't know what's nonsense and what's part of it. You get what I'm saying? But so if you know, I add up all this stuff and put it all together, like, you know, my great grandfather seems to be a landholder for like a lot of America. Like a lot of it. Really, Jazz? The Mormon church? You know what, Johnny? I'm having a problem getting my land patents, yo. I'm starting to get aggravated with this thing. I started with this one land patent that has 160 acres on it in Oklahoma. But from what I understand about this is that I need to go to the Secretary of State in order to get access to the actual deeds. Oh, okay. Hey, what up, cuz? I was just talking about you. I was just talking about how we were having conversations about this stuff. Oh, that was just one of the patents. One of the patents had 160 acres on it. That was just the first one that I found by myself. Now, after having a conversation with my cousin here, who motherfucking made it clear to me that my great grandfather was the president of the bank, I was like, here, let me just check into some other states besides that one. I know, Jazz. I was peeping that out. I was peeping the fact that they were called Mormons, but I've heard that the Mormons think that that people of color were here to be punished. You got any clarity on that? Wise one is my cousin. Just so you guys know, that's my real blood cousin right there. And if you go pay attention to what he's been doing, he's pretty much on the same exact mission that I'm on. Oh, word. Well, look, I'm going to just show you the one that I had found originally. It was in Oklahoma. Boop. Boop. Oh. Shit, I don't even remember which one it is now. Because now I put the W in there, which made it more direct. But look, everything that comes up in Oklahoma is in the Indian and the Cimarron, which is the borderlines of where all the Indian territories were. So there is some truth behind it. Wait a minute, wise one. What? We do have a Joseph Smith in our fucking family tree. Holy shit. Wait, what? That's the wait, that's the Joseph Smith? The founder of the Mormons? Is that what you're telling me? Shut the fuck up. No. Wow. Holy shit. Holy shit, though. Oh, man. That's fucking wild. Oh, damn, you just made me clap my hand, man. That shit's broken. That hurt. Oh, man. Huh. Oh, y'all gonna have to fill me in on all the Mormon stuff, because you know what I always used about the Mormons? I always said that the Mormons were the ones that were the most honest about where their foundation came from, because they were talking about the Egyptian tablet that they had actually gotten it from, where they found it in America, and that was probably the most realistic out of everybody in all of these so-called religions that got created, due to the fact that they actually acknowledged the fact that they got it off an Egyptian tablet. So that's wild. I didn't even realize that that's who that was, man. Because look, so wait a minute, hold on a second. Where's my fucking family tree? Hold on a second. Hold on, I gotta look at this real quick. Hold on, this is making a lot more sense as to why I'm so invested in all these different things and why these things are so important to me. Hold on a second. Okay, right. So we got John Smith here. We got Moses Smith. See, I haven't really been able to dig out the whole Smith side of the family yet. There's John Smith there. Joanna, Martin, Mary, Naomi, Oscar, Lorena, Rosa, Jesse. Oh, you got to add that in there. I need your help, man. I need your help trying to fill this stuff out. Because so far, this is all I've found in the family tree before I started questioning the stuff that Ancestry.com was showing me. Oh, I put a whole video out on how to go through the Bureau of Land Management. What do you mean, Maui? No, Justin, I'm not just connecting every person. That's why I stopped fucking messing with the tree, because I only could verify the people that my grandmother told me about. All right. So I didn't want to just add in random fucking people into my family tree. Okay. Where the name starts the date. I'm not the best with ancestry.com, you know, so I only added in people that I could verify. So I don't really know how this necessarily works exactly. All right, that's why that's exactly what the conversation I was having with my cousin earlier today was, the fact that, you know, I didn't want to just add random people into my tree. So I asked him to go through and, you know, when he gets some time, he's going to go through and make sure that there's not extra people and stuff like that. No shit. mtDNA. Oh, let me add that on there. mtDNA. Boop. Oh, is it a .com or something, or? What was that family tree? That's my family tree. Now, are you saying that these aren't like the other DNA testing things? I have to get a swab. Okay. So which one are you saying is the legitimate one? Shows you the haplogroups. Okay. Okay. Because this one says it's only $10. I will fucking pay it. But I want this one, right? The government one. Okay. Now let's see, because I'll order this shit right now. I will order this shit ASAP. You want to see something? Because there's something that I want to prove, but I need to be able to actually prove it, to stand on it, rather than just feeling it. Oh, okay. Perfect. Thank you very much. I really appreciate that. That's awesome. See, this is why I keep telling y'all got to do y'all shit publicly, man. If you do your shit publicly, people gonna come with answers that you haven't figured out. But look, ladies and gentlemen, I don't want to run this live for too long, right? Because I got to be able to upload it onto my YouTube channel. So look, for those of you that are going to be studying with me, that, you know, if you want more than just that book that we were just reading from, you know, I got to start a fresh live, okay? But for the people that have been in here that are studying with me, look, if you want access to my library, it's the Book of Johnson. Okay, it's all one word, right? On Cash App and Venmo. And it's a minimal $75 donation. Minimum. Okay. And you make sure that when you do this, that you put your Gmail address as the note. Don't write any extra words. Don't do none of that extra shit. Okay? All right, cuz. Yeah, underrated. We just found each other 2 days ago. We literally just found each other 2 days ago because I put up a post explaining to people how to get on the what do you call it? How to get on the Bureau of Land Management to find their land that's in their ancestry, and that led to him seeing it and being like, "Hey, why is your grandfather my grandfather?" Right, so now we've already started fucking working together, and we got a lot of things in the works right now, and fucking we're gonna be getting some shit together. So it seems like we're both doing the same things as far as like, all the trust stuff that I talked to you guys about. He's already done everything, and so he's gonna be helping me as I venture through my trust setups and things like that. So we're networking now and building inside the family, which is fucking awesome, because that's exactly what I've been looking for. And just like me, on his side of the family, he's the only person that's looking into these things, and nobody fucks with him because he looks at these things, just the same way as nobody fucks with me on my side of the family for looking into these things. So building, man, we're fucking building over here. Shit's getting serious. It's getting real. So loving it, right? We're fucking loving it. Yeah, I've only got my estate registered, and I've only got one trust set up, and my unincorporated business, and that's it. So I've been doing all this studying to find out how I wanted to structure it after that. That's what I've been looking for. So since he's already complete with anything, and he told me that he even has his Indian card and everything. So motherfucking, that's pretty much the exact shit that I was trying to move forward to, that I've been trying to make myself more fluent in before I started filling out paperwork, which is why I tell everybody that, I've been studying this for like 4 or 5 years, but I've only made a few moves to put myself in the private, because I just wanted to start off with being private, but, I want to know what I'm doing before I move forward with anything else. That's why I get concerned when people that don't know the things that I know are in my inbox asking me how to fucking fill out extra papers. I'm like, look, like, not for nothing, but you should be studying. You shouldn't just be filling out papers. So I'm gonna catch y'all later. I gotta shut this down before it gets too long. I think I've been on here for a couple hours already, and I gotta shut this down, close it out, upload it up to YouTube, and then I'll be back. All right. So I will catch y'all later. Thank y'all for hanging out, and I hope to see you on the next study session. You can't teach nothing to the Africans, bro. You can't teach nothing to the Africans, because Africa didn't exist until 1930s, I believe. And so they don't even know who they are. So how can they tell you about anything educational? Catch y'all later. That's why I don't argue with them. Africans weren't Africans until like the 1930s. Okay? That's when that place officially got called Africa. That's not even the name of it. It's Alkebulan. But some reason they're all conforming to an English construct called Africa. So if they don't know who they are, how can they tell you who you are? They can't. They don't even have a leg to stand on, because they stand on this. Make sense? But yeah, let me hop off of here. I will catch y'all later.